Good evening, everyone. We are just waiting for a handful of stragglers, then we'll get started in a minute or so. While we're waiting, I'm just going to do a little bit of housekeeping. For those of you who are watching live, we do have a Q&A function. So if you pop those in the Q&A section, we'll try to deal with as many of your questions at the end of the presentation as we're able to do so with the time available. If we don't get to your question, we'll get back to you offline if we can. And if you are watching this on demand, please do feel free to call us at any time on the DDU's 24-hour advice line if you are a member. If you do lose connection during the live version, simply just rejoin the webinar as you did get here in the first place. And just in terms of CPD certificates, you'll get an email tomorrow for those of you attending live and afterwards if you're doing this on demand. I'm now going to pass over to my colleague Anne Budenberg, who's going to talk about confidentiality.
Thank you, Simon. Welcome to everyone. Hope you've all had a good day, and we are going to talk about confidentiality over the next hour, sort of between us. We're just going to take you through the basic principles of confidentiality and how it applies to you, and not just to you, but the whole of the team in the practice, so non-clinical staff, i.e. non-registrants as well as registrants. And as Simon said, any queries at all about anything or confidentiality, you can always ring the DDU advice line. So I'm not going to spend any time on this. This is aims and objectives. This will all be outlined on your CPD certificate, and likewise this will be on your CPD certificate. So if we just move into confidentiality, straight into it, and what is confidential information, and I think if we look at the first principles of confidentiality, we all need basic and personal information from patients to help and advise and of course treat them appropriately. And really it's all the information that you come to know about the patient in the course of that professional relationship with them, which must be treated as confidential. And of course, we are in a very privileged position, position of trust, and all patients have a right to privacy. And you should only use the information that you receive for the purposes it is given. So as you can see here, what's confidential? Well, obviously we've got clinical records, the most obvious thing, but of course it extends beyond that to any correspondence you have between you and the patient. So emails, telephone conversations, appointment information, costs, treatment plans. And of course, as you know, in that professional relationship with patients, especially once you get to know patients, they often open up and tell you all sorts of personal information and stories about themselves, their family. And again, this information should remain confidential. Some of this is, nothing to do with clinical, but just generally what they're doing in their life. So this applies, again, this applies to all staff in the practice. So there'll be some repetition on this because I think it's just really important to hear that point that this applies to all staff. So reception staff, nurses, and it's very easy for confidentiality to be breached unwittingly. So just moving on. So what are your obligations as a dental professional? So you've got a number of obligations. You obviously got a legal duty, you've got a professional duty, and you've also got contractual duty. So obviously the ethical duty, Hippocratic oath, GDC standards, and most of us have got some kind of contractual requirement. So either in your practice as an employee or as a self-employed associate, hygienist, therapist. And of course, the practice as a whole has got usually a contract with an organisation such as the NHS, again, which sets out what you can and cannot do. So if we look at first of all, your legal duty. So there are several acts of Parliament that determine how information must be managed. And of course, we're hearing all the time about breaches of confidentiality. Every week there's another breach of confidentiality. And of course, the law protects information shared within the dentist patient relationship and also the employer-employee relationship. So, legal duty. I think we're all very familiar with the General Data Protection Regulations, GDPR. And of course, when data is being processed, it must be done so in accordance with the legislation. So GDPR applies throughout the EU. And of course, people thought, was this going to change during Brexit? But of course, since Brexit, it's just been incorporated into UK legislation. So since Brexit, EU GDPR provisions have been incorporated directly into UK law as UK GDPR. And the Data Protection Act sets out the data protection framework in the UK alongside the UK GDPR. And as you're well aware, all healthcare and other organisations have to comply with the Data Protection Act. So if we just go through the basic principles of GDPR, again, something I'm sure you're very familiar with, but the basic principles are very similar to the previous Data Protection Act of 1988, but with just a slightly different emphasis. And of course, this sets out the main responsibilities for organizations into seven key principles. So if we just look at those, data should be processed lawfully, fairly, and in a transparent manner. It should be collected for specified, explicit, and legitimate purposes. So you don't want to collect more information than you actually need. So this is called purpose limitation. It should be adequate, relevant, limited to what is necessary. And it needs to be accurate. So the data you hold for patients should be accurate and should be kept up to date. Moving on, so it should also be kept in a form which permits identification of data subjects for no longer than is necessary. So you're not keeping data indefinitely. So this is under the category of storage limitation. Again, it should be processed in a manner that ensures security, protection of data. So this, again, they classify this as the integrity and confidentiality of the data. And there'll be somebody in the practice who'll be responsible and has to demonstrate compliance with this, with systems in place to protect and manage the information. This is the accountability, which is the data controllers have to explicitly state how they are responsible for the data and how they comply with this. So again, you can see it's quite onerous in a practice to keep those systems up to date. The data controller is responsible for keeping this data secure, and policies for staff training, staff induction are really, really important. So moving on to, so what is GDPR data controller? So who is the data controller? And we get a number of questions about this on the advice line. So the Data Protection Act draws a distinction between the data controller and the data processor. And of course, the controller is responsible for compliance and data protection laws, and they must exercise control and are involved in making decisions when any data is going to be released from the practice. So, for example, subject to access requests, which is something that Simon's going to cover in the second half of the presentation. The data controller, of course, is usually the practice owner, and the other staff are the data processors. Data processors are those who are processing data on behalf of the controller. So that's most of the staff, it's self-employed associates, hygienists, therapists. And the processing is what you do on a daily basis. So you're obtaining information from patients, you're recording it, holding it, retrieving it, disclosing it. You may have to use information for referrals, and you're destroying the information or data at some point in time. And you do this all on behalf of the data controller. It's not uncommon that we're sometimes asked by self-employed associates, therapists, or hygienists if they actually need to register with the Information Commissioner's office. And of course, in general, as I've just said, if you're working in a practice run by somebody else, then there is no need for you to register with the ICO. So if you're simply inputting patient records and other data into the practice computer, you're a processor and you're not a controller. And it's only the controllers that need to register with the ICO. However, there's always exceptions to those rules. However, if you take patient data out of the practice, or you personally hold it on your own computer or in a hard copy, you become the controller, or you become a controller, and you do need to be registered. So if you've got any doubts about this, or you're being asked to do this by a practice owner, you can ring us and we can advise you accordingly. And although it's very cheap to register, there's always a temptation to just do it anyway. And the advice we normally give is don't do it because it's easy and cheap to do it, because you take on some quite onerous responsibilities if you do that. So we all have rights as the public and patients. We have a number of rights for our data to be kept private. And I think really points the right to be informed, that and point two, the right of access, such as subject access requests, they're fairly self-explanatory. But point three and point four, so this point, right of rectification, probably worth mentioning. If a patient disputes an entry in the records, and this is not unusual after a patient has requested their records, they start going through the records and saying, I don't agree with this, that's not right, you didn't do that, then the advice is that it should not be removed. You can put a note to say that they disagree, and you can add their comments, but you should not remove it. So likewise with point four, again, this right of erasure. So it applies in some contexts, but probably not really in the health context. And sometimes patients do ask you just to delete something. But in general, if a patient demands a deletion, I would suggest that you contact DDU before you take any action. But in general, this will not apply in most healthcare settings. And you would look at it on a case-by-case basis. So again, this is fairly, I think, self-explanatory, that the patients have a right to restrict the processing. They've a right for their data to be portable. They can object, the right to object, and they also have a right to against any form of profiling and this sort of automated decision making. So just coming on to, so if you do have a breach, again, we get a number of calls about this. You know, this is what you can see here that Article 4 of GDPR describes a data breach. So you can see that for yourself there, it's unlawful, accidental, unlawful destruction, loss, alteration, unauthorized disclosure to personal data. And the ICO defines a data breach as a security incident that has affected the confidentiality, integrity, or availability of personal data. So from a practical point of view, if you think there's been a data breach in the practice, small or large, then you can use, there's a self-assessment tool on the ICO website so that you can carry out a self-assessment. You can always ring us for advice, but this is a very helpful tool that you can use, answer just a number of fairly straightforward questions, and at the end of it, it tells you whether you need to report that or not to the ICO. So basically, in summary, there's no requirement to notify the ICO about all data breaches. However, if there is a breach, you need to keep a note of why you came to your decision, the steps that you need to follow, and if any new information comes to light, then you can reassess the risk. So it's really just keeping a good audit trail of how you came to your decision. Any concerns at all about this, if this happens to you, then you can contact DDU for advice. So assuming there has been a breach which is significant enough to be reportable to the ICO, it's the data controller who must report the breach. And this breach, there's specific timeframes for reporting of the breach. And it's really, if it's going to have a significant impact on someone, it must be reported. And it's not within, it's within 72 hours of you becoming aware of the breach. It may be necessary to also notify the patient, but again, I would seek advice from DDU before you do this. And it's important that you contact a patient as soon as possible if it's high risk that they're going to suffer an adverse effect from this. So again, it's really very much on a case-by-case basis. There's not always just one answer to this. It depends on the severity of the breach. So again, just comes back to reinforcing this with staff. Really important that when new staff join the practice, there's good staff induction, and again, there's ongoing training, just so that people are constantly reminded of this. Obviously, failure to notify results in fairly high fines, and you can see there's a fantastic website, ICO website. ICO are very helpful. Pick up the phone and speak to them. Very approachable, and they also have good information on their website. So we are coming to, this is your ethical and professional obligations of confidentiality. So confidentiality obviously is central to this relationship that we have with patients, and the trust that we have. GDC state Principle 4 that you must protect confidentiality of patients' information. And again, same thing, use it for the purposes for which it was given. And only release patients' information without their permission in exceptional circumstances. And Simon's going to cover this in the second part. And again, reiterating the same message, keeping patients' information secure at all times. And of course, breaching confidentiality has a big impact on patients potentially, but also big impact on registrants, because it could result in a complaint or an investigation by the regulatory body. So breaches of confidentiality can, of course, be doubly negative. Not only can they cause harm to patients, but it can seriously damage that trust that we have, which we need with patients, and reputational damage, unwanted publicity. So it's very kind of important to stay vigilant with this. Coming on to the contractual duty that we have. So in most dental practices, all staff, including the cleaners, should be aware of their responsibilities to maintain confidentiality. So when you join a practice, this duty of confidentiality is normally set out in staff contracts, whether you are an employee or whether you're self-employed. So you as an individual, you contract with the practice or you contract with the organization in which you work. And as I've said, again, duty of confidentiality extends to non-registrant members of the team, and it's important for you to reinforce this. But there's often complaints about staff talking about patients in reception area, surgery doors being left open when other patients can hear. So it depends on the setup of your practice, but there are complaints that come in where the patient has been very conscious that their very private conversation has been overheard in the waiting room. And then coming on to the sort of hot topic of social media. So social media, again, exactly the same boundaries apply with social media as it does to face-to-face conversations. However, of course, social media boundaries between public and private life have become blurred. And of course, by default, social media is about sharing information widely and usually with as many people as possible. And of course, is not focused on privacy. But if you look at the GDC standards, and they have significant amount of guidance on this, GDC standards expect the same principles, same standards, whether you communicate online, social media platforms, or whether you have interactions on a face-to-face basis. Exactly the same applies. So when you're using social media, you just need to make sure if you're on, whether you're on closed forums, Instagram, Facebook, all platforms that can be educational, very beneficial, where you're actually looking at you're discussing with peers, patient cases, etc. It's really important that before you do any posting online, you have consent from the patient, and the consent that you have must be very specific. So the consent is letting the patient know exactly what's going to happen with that image, with that x-ray, with their study models, and where you intend to post it. You need a very patient-specific consent form. How it's going to be stored, who you'll share it with, who they'll, what they'll see. There occasionally you see complaints with a patient who have consented to their image being posted as long as it's anonymized, but only their eyes have been blocked out, and in some cases it's just not been enough. They've been easily identified. So they have been identified by a friend or a family member. And of course, you've just got to bear in mind, you've really got to stop yourself before you post and think, where's this going? Do I have the appropriate consent? Very difficult to retrieve it once it's gone out there because, of course, you don't know who's going to repost it. And again, your practice will have very specific, or practice organization that you work with will normally have very specific guidance on social media and how you interact with it. So you can get into very hot water with this, not only with GDC, but in terms of employment. So just be careful with even closed forums. My mouse is just disappearing. Okay, so just coming on to, it's not uncommon for CCTV to be installed in practices, and this is really a whole topic in itself. So I think if you do have any queries about CCTV, either that you're installing in your practice or that is being installed in the practice, and you're concerned about doing the right thing, or you feel as though it's being used inappropriately, then I think if you can call DDU and ask about the specific case. But the recordings you make, of course, are regulated by the ICO, and there's specific things and guidance that you must follow. I think it's just worth saying, and this is probably an unusual situation, but if cameras were in the surgeries, and some practices do have a camera in the surgery, you would have to be aware that that recording will actually form part of the clinical record for the patients, and they must give their explicit consent to the recording. So be careful with that if you do that. And of course, it also means that you've got to be in a position where you can turn the camera off if they decline. So I'm just going to hand back to Simon here.
Thanks, Anne. Just before we move on to the next section, I thought I'd pose you a scenario just to sort of illustrate what you've been talking about. So the scenario is a dentist called the DDU to advise that they've received some negative online criticism from an anonymous patient. They're 100% sure they know who it is based on the details given about the treatment, and they sought advice on how to respond or whether to ask for the review to be taken down. What do you think?
Yeah, so we go through phases where we get quite a few of those calls in similar to this. So, and of course, we're all being asked for feedback now. And of course, many practices will automatically ask for feedback at the end of a course of treatment and ask the patient, can you post a review for us on Google? Google, or some practices will send a text message at the end of treatment asking for feedback. So it's just the way the world is. And of course, it's a double-edged sword. Most of the time, patient's perfectly happy, but of course, sometimes you're not aware that you've got an unhappy patient, and it can aggravate the patient, and it can be just they can sort of let off steam with this comment. So I would say in this particular scenario, the first thing you say, you can't breach patient confidentiality online, obviously. Often this is an anonymous post, and quite often the practice will think, we know who that is, we know exactly who it is, but of course you can't be sure. So you can only respond in the same way that you would to any other complaint. So you can acknowledge it online, acknowledge their dissatisfaction, offer an apology, and ask the patient to contact the practice to discuss their concerns. You can't write to anyone because you're not absolutely sure of their identity. If you were sure of their identity, and they've actually posted their name, might be different if you're absolutely sure. But again, I would seek advice from DDU before you proceed. And of course, it can be really upsetting having this criticism in the public domain. And sometimes they name you as the clinician, makes you very angry. But again, you've got to step back, and you can't get involved in online discussions. In terms of asking the patient to remove it, again, that can actually make the situation worse. So again, we usually advise not to do that, although you really, really want it removed. But I think if you've acknowledged it, it shows that you are taking a professional approach to your complaints. You've not ignored it. But certainly it can actually make the situation worse if you actually try and ask the patient to remove it, and sometimes they start posting it in different places, so it can escalate. I think that's, unless you've got anything else to add on that, Simon.
Oh, no, that was comprehensive. Well, thank you for
Okay.
that. I'll move on. So just going to move on to disclosure, and just to summarize what Anne's been talking about in the first part of the presentation. Again, it's really important to reiterate that any information you hold about a patient is confidentiality. Even the fact that they are a patient is confidential. So in this section, I'm going to talk about the circumstances when you might disclose confidential patient information, either with their consent or without it. Before I do go on to do that, though, I thought it would be important to discuss who is responsible. Again, I know Anne has touched on data controllers, but if you are considering disclosing patient information, it is important that you speak to the data controller at the practice, or if you're in a separate organization, there are other roles like the Cold Guardian and so on. But the person who is ultimately responsible for that information needs to be consulted before you disclose anything. So if you are not the ICO registered data controller responsible for the practice's information overall, then you shouldn't really be disclosing anything until you've spoken to them. However, the task of actually disclosing the information is perfectly reasonable to give that to a responsible staff member, but they need to be trained and competent in doing that, because ultimately it is the ICO registered data controller who is responsible, and they could, again, receive significant fines if there is a data breach. So in terms of disclosure, there's usually 3 scenarios where you will need to consider whether to disclose confidential patient information. The first is a subject access request, and that's when a patient or the representative has asked for that information directly. The second is when someone else asks for it, and they'll be talking about third-party requests later on. And the third is a circumstance where you might disclose the information to protect the patient or others because it's in the public interest to do so. So no one's asked for that information, but you think it's important to make a disclosure or notification because there's a more important reason to do so. And I'll sort of cover all of these over the next few slides. So starting with subject access requests. Well, any competent patient has a legal right to request a copy of any of the personal information you store about them, such as their dental records. And there are, of course, circumstances where that person might not be able to do it for themselves, for example, children, and others will do it on their behalf. So if you've got a child, for example, someone with parental responsibility can make a request on behalf of that child. I'll talk about that in a bit more detail in a moment. There's also situations where they might have a legal representative, like a solicitor, who might make a request on behalf of a patient who is considering a claim. Now, just because they're requesting information from you and it's from a solicitor investigating a claim doesn't mean that that claim is against you. It might actually be about someone else, but they need to gather all the relevant information from all the clinicians that have been involved in the care. If you ever get a request like that, just call your indemnity provider straight away. Sometimes a subject access request can come from someone with an LPA, a lasting power of attorney, usually specifically for welfare, and they can request records on behalf of a patient. but they should have the relevant documentation in place to prove that they have the LPA, and they should only really use that if the patient themselves is at the point where they can't make their own decisions about their welfare and they can't consent for themselves. Otherwise, they'll go to the patient. And more recently, actually, the DDU is seeing more advocacy groups requesting information to help patients understand or complain about the dental care. We have now seen quite a lot of patients with diagnosed late in life autism spectrum disorders who have struggled to communicate their needs or concerns in the past, and they now have access to advocacy groups that can support them and communicate a request on behalf of a patient. Just going back to parental responsibility, it is really important to remember that children have that same right to confidentiality as adult patients. Someone with parental responsibility can request that child's dental records, and generally, if that's a valid request, you should comply with the data controller's input. But you might, on occasion, refuse a request for a child's information if you think that disclosing the information could lead to harm, or if certain information was given to you by that child in confidence. It's a bit of a complex and fraught area, that. So if you're in any doubt, just delay and seek some advice. And you can always get back to the person making the request once you've taken that advice. For children aged 16 and 17, because they're beyond that age of consent, you do need to assess whether that child's mature enough and whether it's in the best interest to disclose. But in general, most 16 and 17-year-olds are sufficiently mature to make that decision, so you should seek their consent before you disclose information to their parent. And if you're getting a parent asking about any child, or well, no longer a child over 18, then parental responsibility is no longer relevant because over 18s are adults. So there are other mechanisms where some representatives can request information about those patients, but parental responsibility isn't the mechanism. Just to talk about when parental responsibility actually applies, well, it does change from one region to the next in the UK. There are different bits of legislation in the different countries in the UK, and we've got information about that on our website. But generally speaking, it's automatic for the birth mother. They automatically have parental responsibility, but it can be removed from them by a court. A father also automatically has PR if they were married to the mother at birth, or if they're named on the birth certificate. That's generally fully kicked in now because most of the countries have sort of changed the relevant legislation to make that happen. There are various other mechanisms as well that can happen through the courts. For example, adoption orders, there could be court-appointed guardians. Step parents can later request parental responsibility. For example, they marry into a family and take over this sort of responsibility for the kids. But if you're in doubt, the simplest thing to do is always just ask the person, say, you know, what mechanism gives you parental responsibility here? Have a bit of a suspicion about whether that's accurate or not. And again, you can always say, well, listen, let me take down your request, let me get some advice, and I'll come back to you, and then you can proceed accordingly. So when you do receive an SAR and you've talked to the data controller and it's valid, you have 1 calendar month to make that disclosure, which is actually, you know, it's longer than most timescales and complaints procedures. And we'll often see complaints come along with a request for records. You've got a month to deal with the records request. Generally speaking, that's because it's often administratively time consuming. It can be extended by a couple of months if it's a very complex request, or if there are multiple requests from the same person. But to be honest, that caveat doesn't really apply in dentistry. We're not holding anywhere near the volume of information where that would probably kick in. If you're working in a hospital setting where it's entwined within lots of other hospital records and various other sites and so on, then that's different. But in a general practice setting, it's 1 month. And just on the subject of fees, the GDPR and the Data Protection Act are very, very clear. You cannot charge a patient or the representative for a copy of the records under an SAR. You can, however, charge a fee for making a report or interpreting things, and generally if that request goes beyond providing a simple copy of the records, then you might levy a charge and agree that with the person requesting in advance. And again, you have to weigh up, you know, time and the rest of it, and you can always seek their advice if you're not sure what to do. And just lastly on the SARs, just talking about deceased patients. A patient's right to confidentiality does extend beyond their death. We sometimes find ourselves being asked for information from family members of deceased patients. But it's really, really important to remember that the next of kin doesn't have any automatic right to the deceased patient's information. There are some circumstances where individuals can legally request that information about a deceased patient, but usually they have to be a personal representative of the patient. By personal representative, what I mean is maybe the executor of their will or the administrator of their estate. And again, they should be able to sort of prove that if need be. Again, defer any sort of disclosure until you're quite confident that it's a legitimate and authorized request. There are situations where a patient might have insisted that actually nothing is disclosed about them beyond their death while they were still alive, and you should generally respect their wishes. If, again, you get a request like that, you're always going to want to call your defence organisation for a bit of advice because it's so niche and so rarely going to happen that you'll always want to give us a call just to sense check what you're doing. The other circumstance where someone might legitimately request a copy of a deceased patient's records is when they might have a claim arising out of that patient's death. Again, that's a pretty grim and very rare occurrence for a dental practice, but there are some times where the partner might be making a claim in negligence against a practitioner or a practice. There are other people who are interested in patients' records as well when they're deceased, but we're going to get on to third-party requests in a second. Just before I do that, though, I'm just going to touch on what happens with patient complaints. Generally speaking, if a patient has complained about their own clinical care, to be honest, you can obviously use their confidential information in order to respond to that complaint. It's not really a problem in that scenario. However, sometimes the person making the complaint isn't the patient. And in that scenario, you should pretty much always say, hang on, do I have the patient's consent to disclose this information to that person? Or does this person have some sort of responsibility, like, for example, parental responsibility? And again, that's something you might discuss with the data controller before you respond to a patient complaint. If you've satisfied yourself that the complainant does have authority, then you can carry on and respond to the complainant. But if you don't have that patient's consent and you're unable to obtain it, then you would not respond to that person. But what you can do is either go and seek the consent of the patient yourself and say, listen, so-and-so has made a complaint about you and your care. Can we respond to them, or do you prefer that we respond to you, and have that discussion with them? If you can't get hold of them, that they're just not getting back to you and you can't get that consent, a sort of backstop is always that you can respond to the concerns that have been raised, but address your response to the actual patient, basically starting by saying, we've received these concerns about your care. We want to provide you with a response. We're happy for you to share this response with the complainant if you're happy to do so, and we get round it that way. Sharing records with, for example, a departed associate or therapist that's left the practice, for example, you can usually do that if your practice privacy notice allows for it. Most practice privacy notices will explain the circumstances where information will be shared with other individuals for legitimate purposes, one of the criteria that Anne talked about earlier. And legitimate purposes includes sharing information with people involved in dealing with complaints if you set that out in your practice privacy notice. Otherwise, if you don't have that in your practice privacy notice, you will need to get the data controller to confirm with the patient that they're happy for that information to be shared with the departed associate in that situation. Generally speaking, defence organisations only want to see anonymised records, so it's very rare that practices, associates really get sticky about this, but we do see it happen from time to time. And again, if you're not ever sure, just call your defence organisation for a bit of advice. So just moving on to those third-party requests. So we've talked about subject access requests, requests direct from the patient or the representatives. Third parties might also be interested to obtain some confidential information. For example, we've talked about solicitors and claims, but solicitors don't always contact you about claims. They might be acting on behalf of a patient or a relative in a family law matter where there's a bit of a dispute about childcare and so on, and they need that information as part of a wider legal process. Another example of third-party requests, we commonly see the police arrive asking for a little bit of information. They might be acting in the prevention of a crime, but they also might just be acting on behalf of the coroner, and the coroner will usually instruct the police to go and get information. as part of an inquest. Social workers often contact practices seeking information about vulnerable patients like children or vulnerable adults. And indeed, as part of a third-party investigation, like a GDC investigation, the NHS, CQC, and so on, they might request information about patients that's confidential to inform their investigation. And lastly, for perfectly legitimate reasons, the patient's new dentist might ask for some information. They might want to see some recent radiographs that you've taken, or indeed, if you've referred a patient to a hospital and so on, they might ask you for more information. Some of that will be covered off in the practice privacy notice, again, disclosing information for the purposes of the patient's care, for example, to a referral target, it's usually covered off pretty easily in those. But if it's a new dentist and that's not necessarily covered, then you might just check with the patient, are you happy for me to give your x-rays to this new dentist? And usually they are, and it's them that's asked you in the first place, to be honest. With third-party requests, as a general rule, you just must always consider that the information is confidential, and as a general rule, always seek the consent of the patient or their legal guardian to disclose that confidential information to the third party. So that's always your starting point with any disclosure consideration. There are some times where you might not, though, and there are circumstances where you might breach confidentiality, because that's what you're doing. If you disclose information without the patient's consent, you are breaching their confidentiality. There are times when you can do that without the consent, or you might do it without the consent. One is, for example, if you're legally required to. There's some legislation that requires you to make a disclosure if, for example, there's a potential road traffic offence. And, for example, if you've got a patient who's sedated and then you see them get in the car and drive off, again, you'd be required to act. The court might order you to. So you do not necessarily need the patient's consent to disclose information to a court, because a court can legally demand that you produce certain information. And if you do get an order like that, pass it to the data controller, they shouldn't really have any issue with it, and they should disclose precisely what's been asked for, but again, limit it to what has been asked for. They shouldn't go beyond that. The coroner, and we talked about deceased patients, but the coroner might instruct the police to come to you and ask for patient records as part of an investigation, and they've got very wide-reaching powers to do so. So if a request has come from a coroner, there's usually some paperwork to accompany that, then that request, there's no seeking consent in that scenario, you just disclose the information. There's also situations where you might just do so because it's in the overriding public interest, and I'll go on to talk about that in a second. But in any of these situations, if you haven't got the patient's consent, you have to sort of think, do I need it? If you don't need it, do I tell them that I've made this disclosure? Usually it's a good idea, unless there's a good reason not to. But generally speaking, it's a good idea to let a patient know that you're giving away their confidential patient information to a third party, because the last thing you want is that sort of breakdown in trust when they think you've been informing on them behind the back. Again, it's important to sort of bear that in mind. Just going back to police requests, these are, again, third-party requests, but the police really don't have an automatic right to access confidential information about patients. They don't have any power to secure dental records unless they've actually got a warrant, a court order signed by a judge instructing you to disclose certain information. And again, you should only disclose what's been asked for and nothing more. There are some specific provisions where you might have to disclose to the police. For example, we talked about the Road Traffic Act a moment ago. Sometimes they do cite this overriding public interest or disclosing information for the purpose of prevention of a serious crime. Again, just because they've said that doesn't mean that's necessarily important enough for you to breach confidentiality. Again, that confidentiality is sacrosanct, and there are very rare occasions where you would breach it. So you might want to know, well, what is this crime that warrants me breaching this patient's confidentiality? And you can ask the police that, and their answer might influence your decision making. You might want to ask what it is they actually need to know, because if it is just something quite basic, like did they attend on this day, then that limited information might be worth breaching confidentiality, or at least something you might consider doing in the circumstances described. And again, limiting the information you disclose is really important. And again, you have to think, is the whole record necessary here? If they've asked for all the records, but you think, actually, no, it's not relevant to your inquiries, I'll give you what I think you need in the first instance, and if you need more, come back with a good reason. You also need to think, well, hang on, guys, have you actually ask the patient for their consent to disclose this information, and if not, why haven't you? Sometimes there's a very good reason why they haven't, because it might actually tip them off to an investigation, for example. And again, the public interest issue comes in there, and again, they might be able to convince you that in a situation that you shouldn't be seeking the patient's consent. Again, you can ask them as much as you want in order to help you make that decision. If you're ever in doubt, don't disclose anything straight away. Take down their details, take down what they're asking for, and then go and get some advice before you respond, and then you can always respond later. Until now, I've been talking about what you need to consider when someone asks for confidential patient information, whether that be a subject access request or a third-party request. But it isn't always the case if someone's asking for it. You might consider there are circumstances where you're obliged to share that confidential information for public interest purposes. There's a number of circumstances listed on this slide, ranging from safeguarding concerns to notifications about serious communicable diseases. And again, in any of these situations where you're really thinking about breaching someone's confidentiality of this nature, just remember the DDU has this 24-hour advice line. Doesn't affect your subscriptions whatsoever to call us. Just call us for a sense check. You'll get through to an advisor within moments, and they'll be able to answer your questions and keep you right. It is obviously a bit of a balancing act when you're considering any of these public interest disclosures. If you're going to breach a patient's confidentiality, you've got to weigh up your relationship with them and the potential harms of doing so with the potential benefits to either the individual if it's a safety concern about them, or to society if it's a general safety concern like the road traffic situation. And it is tough, and we always advise that when you're making these decisions, make sure you document your decision-making process, no matter what the outcome, in the clinical notes to say, we've had this request, this is what we've weighed up, this is where we got to, and this is what we did. So that if ever there's a complaint about your decision to make a disclosure, you can show your working, you can say why you disclose that information. Whenever I've sort of faced a decision like this, I've always tried to apply a bit of method to the approach. The first thing I always think about, well, is this my decision to make? And we've talked about this at the start, unless you are the data controller for the practice, you might not have any responsibility for making this decision whatsoever. If you're an associate, therapist, hygienist, or staff member of any aspect of the team, you should always go to the data controller for a sense check before you make a disclosure, and therefore decisions taken out of your hands. But if you are making a decision, you need to then ask, right, okay, I'm making a decision. Do I need this patient's consent? In most cases, in almost all cases, you do. But in some rare circumstances, you may be legally compelled to disclose information regardless of the patient's consent. So yes, you do need it, but sometimes the court can make an order, for example, and then you just have to do it anyway. If you do need the patient's consent, then you have to ask yourself, do I have it? And the patient might have already told you, yes, I'm happy for you to disclose it to this person, so job done. If you don't have it, though, you need to think, right, should I go looking for it? And in that situation, you have to consider whether there might be a reason not to ask for it. So, for example, there are certain situations where you think, oh, hang on, by asking this patient, I might be putting them at risk or someone else at risk. And they're quite niche, and again, that's something you need to sort of take advice on before you do it. If you go looking for that patient's consent and they refuse it, generally speaking, you should just agree to their request to refuse disclosure, note that in the notes, and then not disclose it and tell the third party that's the decision. They still have the option to go and get a warrant, a court order if they're not happy about that decision, or they can contact the person themselves and say, listen, we do need that information for us to progress whatever investigation we're doing, and they might convince the patient to say yes, and they might come back and say, yeah, actually go ahead. But yeah, there are stages to this, but the important thing is to document decision making so that you've got evidence of how you got to where you are. It is just really important to remember that you are not making these decisions by yourself. You do have colleagues in the practice who might have experiences before, have had a disclosure request like this, who you can pick the brains of. There's obviously the data controller, who has the responsibility and should be clued up on how to do this. They will have their own advisors in the background as well. They can have a data protection officer, they can contact their own defense organization or their ICO for advice. And there's always, always, always your defense organization. We're very happy to answer questions about disclosure because it's in ours and your interest to make sure that you don't get yourself in any trouble with this. So I'll just pass back to Anne.
Thanks, Simon. Very comprehensive look through all those amazingly sometimes complex scenarios that we come up. Um, So we're just going to go through this scenario. So this is again quite common that make this kind of request is made. Social worker calls the practice reception asking for details of a 9-year-old patient's recent attendance history. The receptionist isn't sure if she can answer. What should you do? What should she do?
Right. So, well, this is a third-party request. A social worker would be a third party. They're not necessarily representative of the patient. So it's not a subject access request. This is a third-party disclosure request for what is confidential patient information. Again, even the fact that the patient is confidential in this scenario. The receptionist should therefore decline to provide any information at that point in time, but offer to sort of take down the social worker's details and the details of the request and say, we'll pass this to our data controller. Once they've done that, the data controller can then in turn consider the request. They need to consider whether they need to get the patient's consent, or in this case, the consent of someone with parental responsibility. The patient's only 9 years old. As a general rule, I think they will need to get that consent. I think they might first call the social worker though, just to get a sense as to whether there's any reason not to go chasing that consent, because obviously there's a reason the social worker is interested. And it might be that by asking for the consent to speak from the patient or the guardian might interfere with what's going on in the background. So you might just want to get a bit more information from the social worker about what is the nature of your investigation and ask them directly, will me asking them this question cause problems? And again, you can build that into your decision-making process as a data controller. If you get the consent from someone with parental responsibility, you can document that and then disclose the information to the social worker. If the parent in this situation says no, which they often do, to be honest, you can simply tell the social worker, I'm sorry, but we don't have consent to disclose, and I'm afraid the information you've given me isn't enough for me to justify breaching confidentiality. You might want to go and get yourself a court order. And that's, again, just using that filter to sort of get to that point. That's it.
Thanks, Simon. Okay,
Do you have any questions?
So questions. We actually have a question here on social media. Can I ask you this, Simon?
Sure.
So if a registrant was posting on social media, should they be registered with the ICO?
Well, as with most questions like that, it's a big depends. If you are in control of confidential patient information, then the answer is yes. If you're contractually obliged to by the practice, the answer is yes. But in the probably quite unlikely scenario where you're doing everything from a practice system, so you're uploading information from practice systems using secure platforms like that, and the information that you're posting has the patient's consent, the practice owner knows what you're doing, it's being securely uploaded from practice systems, then that probably falls into processing category. But again, it comes down to the specific circumstances. But broadly speaking, most people using social media will be using their own devices to do that. So the minute you start using your own devices and putting patient information on them, you become a data controller. So the likely answer is yes.
Thank you. Yeah, there's never one straight. It's the devil is in the detail, isn't it, with all those things. So again, just ring DDU for advice and anytime. So there's just another question here. Again, this is really about those setups in a surgery. So how does confidentiality work when you're working in a surgery where it's sort of that open plan, and a lot of places are like this where there's a partition between the two surgeries, so it's not totally private. So
Yeah, I mean, we all remember clinics in the dental hospitals where you had to sort of shout over 6 other chairs next to you and so on. It's not unheard of. There are practices that do have these partition systems in place. And again, starting principle is that the information you're discussing with the patient is confidential and should be treated in accordance with all the things that Anne's been talking about. But the problem is yeah, you're right. It could be overheard by someone listening carefully from next door. So I think you just have to be pretty open about that with your patients when they come in. There's probably some signage that sort of explains that, that their consultations may be overheard. If they want more privacy, they'll need to have some discussions with the team to see how they might achieve that. But generally speaking, if patients will notice that there's people nearby. If they've got concerns about it on a practical sense, they're going to be able to sort of speak up if they're worried. And equally, you want to give them the opportunity to speak up if they might be worried. If you know something about them or you're discussing something particularly sensitive, you might just give them a bit of an opportunity to say, well, hang on, no, I don't want to discuss this right now. But for example, if someone's got something in the medical history that they don't necessarily want, people either side to be hearing, again, you might think about how you get around that as a practice, whether that's done in writing beforehand. But if you've got to ask questions about it, you might just say, listen, I want to have a chat with you about your medical history. Is this a good time to discuss it? Are you okay to discuss it now? And obviously they're going to be aware of why you're asking. But yeah, just I think a bit of common sense in those scenarios, but allowing the patient to make a choice to have a conversation in private if need be.
Okay, I think that probably brings us to the end. But I mean, certainly, thank you for attending, for listening to it. And if this has triggered any further questions or you think of anything after the presentation, don't hesitate to contact DDU with any questions on this topic or anything else.
Thank you very much, Anne. And bye all.
Okay, thank you very much. Okay, have a good evening.